Tim Blankenship here with Divorce661 Daily Perspective, episode 62. I'm a legal document preparer in California that handles amicable divorce cases anywhere in California. I work with all the courts. Also like to start off by telling folks thank you for my current clients, past clients, those of you may be considering using my services. I do these daily podcasts to go over things clients are having issues with, things that could come up on consultations, problems people are having with their paperwork, a lot of judgment rejections, as half my clients come to me with cases they've already filed and run into problems with the court, and the other half obviously is people starting from scratch with me. I always like to go over the stats just to kind of let you know where I'm at. We're here April 23rd, and we have 39 divorce cases that we've handled so far this month, 166 so far for the year. And this really spans all counties throughout California. In any given day, we have multiple cases, new cases filed, judgments prepared, settlement agreements drafted, you name it. We touch a lot of files every day, helping our clients get through their amicable divorce. Today, we're going to be talking about quite a bit. I'm going to kind of foreshadow what we're going to discuss here. We're going to talk about how much you should pay for an amicable divorce. Should you get legally separated before you file for divorce? How long-term cohabitation before marriage can result in divorce. I'm also going to talk about judgment rejection issues. Always, I mean, I spend so much of my time reviewing clients' documents that hired me to take over their case after they've had problems, and we're always having reject issues come up, and going over mistakes people are making. Who should be the petitioner in your divorce case, and much, much more. So let's just get right into it. I want to talk to you about a client who hired us last week who was quoted $10,000 for their amicable divorce. And on the call, he said, Tim, how you make the process sound so easy. Why would an attorney want to charge me $10,000? And the answer is because they really don't want your divorce case. They don't necessarily want to take you on as a client for, $2,500, $5,000. That's what I've normally heard. 10,000 was just a lot for an amicable divorce. Normally it's 5,000, 7,500 is what the clients are usually telling me they're seeing, because it doesn't make sense for them. Everyone's busy. Attorneys are busy. They want litigated divorce cases going to court where they can bill their $500 an hour, driving to court, going to trials, thinking about you in bed. And they want billable cases, not a case where they just turn it over to their paralegal staff to do that. So if you're going through an amicable divorce, I would be the right fit for you. Guys do not need an attorney for that. All right, next subject. Should you file for legal separation before divorce? I want to talk about timing on that. So we'll have people oftentimes in consultations say, Tim, should I file for legal separation first before divorce? Like, is it mandatory? They'll say, well, when I ask them for the date of separation, if we're going to do a divorce, they said, well, we're not legally separated. We've only lived apart. Or they'll say something like, we're still living together. You don't need to have a legal separation before you go through a divorce. And many times it won't make sense to do that. So I want to talk about the timing. Sometimes people say, Tim, I want to do the legal separation because I know there's no 6-month cooling off period. And while that might make sense on paper, in reality, dealing with the courts, a legal separation case isn't going to get finalized that much sooner than a divorce case because of all the backlogs with the courts. And this is pretty much anywhere in California. In addition to that, if you finalize a legal separation case and you get a judgment on a legal separation case, then you want to later file for divorce, you have to go through the entire process again. New case number, new filing, new fees, new everything. It's not, a lot of people think, Tim, how do we just, I did a legal separation years ago. How do I turn that into a divorce? Well, you don't. You have to file a brand new divorce case, and you have to start the process over again. The 6 months hasn't even started. Everything starts from scratch, like you never even filed, because in reality, you didn't. Okay, I want to talk about some issues that we're seeing with the courts. We're seeing a lot of new rejections come from settlement agreements that have been drafted for years, the same format, same language, same words. And suddenly we're seeing rejections from different courts. I think what a lot of it has to do with is new clerks, not necessarily new judges. It could be new policies, new procedures. But a lot of it, I think, has to do with new clerks not understanding the process. And I think I'm talking about later in this podcast about um, the fact that there are so many new clerks and that the courts aren't always correct on things. We're usually having to correct them many times, or we'll see. I have some errors, where some court errors I'm going to talk about here in a little bit as well. But we're starting to see some changes. And the issue, the thing I want to discuss here is that ultimately, unfortunately, whether the court's wrong or not, they're in charge. They're the boss. If they say you need to change this or make this modification or change the language to this, even though it's been maybe approved 1,000 times, um, they're going to make us make the change. A lot of times I can argue the point if it's worth arguing for. Otherwise, I tell our clients we're just going to have to make the changes. And sometimes this comes down to things like, and I talk a lot about, having no child support, using reserved jurisdiction language in the settlement agreement. We're having good success with that. And that's how we learn over the last 12 years doing these things. This reserved jurisdiction is fairly new. And it happened to come about because we had put through a no child support order. And the way we used to do it is by saying it's a non-guideline order and no child support due either party type of deal. And the court, and there's the first time I ever seen this, probably a year ago now at this point, they said, if you're going to reserve jurisdiction for child support, then you want to write the word reserve. I said, oh, okay, this must be something new. Perhaps, at least it was to me. And now we've been doing that. Where people don't want an official child support order in their divorce case, and we're just writing reserved, and we're having success with that in many counties: San Diego County, Riverside County, Orange County, Los Angeles County. And now with cases where we are filing in like Contra Costa and a lot of other counties that are, I don't want to say more strict, but I mean, more strict might be the proper phrase. They just do things a little bit differently. I don't think they're as busy as some of our other main courts like LA County, so they have more time to review them. Not that that makes sense, because they're making mistakes in these other counties, but just they have different rules that they're following, it would appear. So we have a lot of these cases and settlement agreements we've submitted to courts where we haven't yet had the approval on the settlement agreement for the reserved jurisdiction. So I'm interested to get those back to see if those get approved, because then in my files, I can notate, yes, this court does allow for the reserved jurisdiction child support. If we have an issue with that, I do have a backup. We're just going to go back to the default of not having or no child support, but doing it as a non-guideline order. The benefit of doing the reserved jurisdiction is the courts weren't asking for the income and expense declaration for either party, whereas most of the courts want an income and expense declaration when we're doing a non-guideline order. Asking, and what I mean by non-guideline is we're saying, yes, child support should, calculated on the disto master is $1,000, but we're asking for zero. So you're asking for that variance, and that's called non-guideline because the calculation is called the guideline order. Let's see what we got next. Clients that have been married for a very short period of time, but they had long duration relationships. I've had several clients this month where they've been together for 5, 8, 10, 12 years. And then they got married. And then when we're doing their divorce paperwork, they've only been, always happens. They've only been married like 1 year, 2 years, 6 months. And so I did a little research. Oh, I deleted it. I did a little research and I asked Google, if you will, they have like a legal portion you can ask. I said, is there any statistics that show that long duration relationships prior to marriage is a reason that people get divorced sooner than later? And it basically said, yes, there are some statistics to show that long-term duration relationships that eventually get married for some reason, didn't say why, end up in shorter duration marriages. So I just thought that was interesting. And I would share that with you because I was seeing so many this week. I want to say it was 3 or 4 where they were together for a long period of time and then they had a short marriage before they hired me. Okay, so I'm going to talk about some judgment reject issues here. I got several I can see in the pipeline here. So let's get started with the notes. Had a court told a client not to do an uncontested divorce so they didn't have to pay the second fee. Generally, that's good advice. That's why I tell you we do the default with written agreement, but then had him file the default without agreement. So as you know, there's 2 types of defaults: default with, default without. And what the word people are familiar with is uncontested divorce. Well, the definition of that is a response is filed. The other process that I put my clients through, if they haven't already paid the response fee, is a default with the written agreement. So when the court gave them the advice of, hey, don't have them file the response to save the fee, that was good. But when they told them to do the default, they were telling them to do it a default without agreement versus default with agreement. So he hired me. He had errors on the petition. The judgment was being rejected. They didn't mark. I'm just looking at some of the errors here. They didn't mark to terminate spouse support. So the default judgment would never get approved. I had several cases like this, people trying to do this default without agreement. They think it's easier. They think their case, that maybe there's no assets, no debts, no kids, which is usually the case. But any mistake you make on the petition is going to cause the judgment to be rejected because the judgment has to mirror and match everything you put in the petition. So in this particular case, he had filed the petition and didn't mark that he wanted to terminate spouse support to both parties. Had he done that, he probably could have got the default without agreement through. But if he was going to try and get that through, he was going to have to amend the petition. And the problem with that is, and the reason I didn't do that in this case, I said, hey, let's just get your spouse involved. Will they sign the paperwork? He said, yeah. I said, great, then let's do that, because the settlement agreement will supersede the petition in a default with agreement or uncontested divorce. Whereas with a default, no agreement, the judgment and settlement agreement, well, there's no settlement agreement if your other spouse isn't participating, but the judgment is what they'll call it, has to mirror the petition. So if there's errors on the petition, you can't make requests in the judgment that weren't on the petition. He would have had to amend his petition. So what we did is, instead of amending the petition, I said, the court will approve it if she gets involved, signs it, notarizes the settlement agreement stating there's no spouse support. And that's what happened. We got that approved in a couple of days. I think there were some other issues in that same rejection, that, just one checkbox being wrong on the judgment is going to cause rejections. Numerous issues in this judgment would have never been approved. So what's interesting about this judgment that was submitted, that he ended up hiring me, we got approved because he's trying to do the default, is the rejection letter, as is very common, only stated a few things. In fact, when I told him, hey, this won't go through because of the issue with the not marking the spouse support on a default, he said, but the court didn't say anything about that. I said, not yet. I said, next time you turn this in, you're going to get rejected for other issues. Next time, again and again and again. And that's what continues to happen. All right, next we have another judgment reject. And here's my notes. If you file the 160s and list assets and debts, all of that has to end up on the judgment/settlement agreement, even if they no longer exist or were sold. So this is why I hate you guys. I shouldn't say hate you. I don't hate you guys. This is why I recommend you guys don't file the property declarations. I know if you're watching this and you've already filed your divorce and you did the e-file, the guide-in file, which is, in my opinion, terrible, it forces you to file the property declarations. And in doing so, not only are you doing it incorrectly, we're seeing people divide property they don't want to divide because they feel like they have to do it equally because that's what they heard in community property and so forth. So many issues there. But what I want to talk about specifically is if you have filed for divorce, and you listed these property declarations, whether or not you did it on the guide-in file or not. A lot of people that filed before the guide-in file was an option, we're still drafting completing the 160s, the property declarations, and attaching them to their petition. Again, all that has to be addressed. Now, even if it's by agreement, and even if the property no longer exists. So what we'll see is several-year-old cases, 2, 3, 4, 5 years old, hire me, take over, judgment rejection issue. And I'll say, okay, well, I need the account information on this. This was listed. I need this vehicle information, things that were listed on the property declaration. And they'll say, Tim, I don't have those anymore. I said, that's fine. You had it at that time, so it now needs to be addressed. When the property declarations are filed, the court is going to basically look at your settlement agreement and then look at your property declarations and make sure everything on the property declaration made its way onto the settlement agreement. If not, it'll be rejected to say all property listed in the petition, because that's what's referring to, needs to be listed in the settlement agreement or the judgment. And so you just make sure you do that, even if you no longer have it. So if you had the car sold and you don't have it anymore, just list it that you're keeping it. It's gone. So it doesn't matter, but you need to address it. Don't leave it not on there. If it makes you feel better, you can put no longer exists, like in parentheses or something like that. Okay. Another rejected judgment issue. I had 2 cases. We're on one 2023 divorce case. They misspelled the first name on the summons, but spelled it correctly on the petition. And on the other 2022 divorce case, we handle these very old cases. Um, they use the full middle name with the petition and just the middle initial on the summons. In both cases, we had to amend the summons and petition. The 2022 divorce case was an easy divorce. I always do the quotations, easy divorce. There's no assets, that's kids support. So 2022 divorce case, they hired me to this, in April here, 24. So call it 2 years, 3 years, 2 years. And they had an easy divorce, no assets, no debts, no kids, and they're struggling to get their case through. And it would never get approved. They're getting reject over reject with their judgment. And it was because of a simple mistake. Names being spelled wrong, names not the names. Here's the simple fact: the names need to match on the summons and petition at the initial filing. If you misspell it, we had one that it was Matthew with one T on the summons and Matthew with two T's properly spelled on the petition. That set their entire case up for failure. No matter what they did, if they did everything else right through that, through from that point forward, it wouldn't matter. We had to amend their petition in that case. Same with the one with the middle name. We had to correct the name right out the gate, and then we could proceed after that. It's not a huge deal. You do get one amendment for free before the court usually will call you in to say, hey, why are we amending so many times? You obviously are having issues. You need to get some help. But if you hire me, you get a professional taking over. We do a full case review, find these issues that, some of these weren't even rejected issues. They weren't even issues that had come up yet. They were being rejected for other reasons. And we are finding, as we often do, multiple reject reasons that the court hasn't even found yet. But don't worry, they will. They just haven't got to it yet because they'll only handle a few rejection issues when you're doing your own divorce, and they will, they have tons of cases to go through. So they're going to, say, wow, this person's doing their own case. It's a mess. I'm going to mark off a few, clear this off my pile of judgments to review, and because they'll submit it and I can review it further next time. All right, next I want to talk about bad information from the courts. You would assume because someone who works for the courts is telling you it would be correct, but it so often is not. I have consultations where clients were told by the court that if they agree to the petition not to do anything, this is a default without agreement case and the hardest to get through the court. The best way is a default with agreement, which is the settlement agreement route. If you agree, always do a settlement agreement. So the defaults, guys and gals, ladies and gentlemen, are really messing you up for every, not every case. The judgment reject cases that clients hire me to take over, I can tell just from reviewing their case summary through the court site that the respondent is not being involved in the case. There's two types: with and without an agreement. Default without agreements, we had, and I don't know if I'm going to talk about that later today. I think I will, but we had a default with, they were amicable. Supposedly, client hired me, short-term marriage, less than 5 years, no spouse support, no kids. In fact, they'd been separated for like 25 years. But the respondent didn't want to end up participating. We filed the case. We tried to communicate with them. They're not engaging, wouldn't do anything. So it forced us in this case to have to have her personally served, which isn't, we don't do with my service because we just have you sign a notice and acknowledgement and avoid that. But she forced that issue because there was no other way to get her served. And then it also forced us to do the default without an agreement. Fortunately, we had filed it in such a way that said there's no assets, no debts, no spouse support, short-term marriage. So there weren't any issues to come up as far as dividing community property, or if it was a long-term marriage over 10 years, having to refile the petition to mark reserve, because that's the rule the court makes you follow in long-term marriages. So she forced us to do the default without an agreement. It's not my preference. And fortunately, it was a type of case that we could get approved without any issues. But generally speaking, don't go that route. 99% of the time, if your judgment's being rejected, and I looked and it's because your spouse, one of the main reasons is because you're not including your spouse. Of course, there's a whole host of other issues you are making or errors you are making in addition to that. All right, next subject. Kern County does not have a default with agreement procedure. So I've been doing this for 12 years, and most of the courts we filed with in California, multiple times per month. And so we know their process, their procedure. The process is 98% identical in all the courts. And then there's, 1 or 2% nuance with that court or even that courtroom if it's a large court like LA County. So, but Kern County, I want to say, like, call it 10 years ago, we're filing a case there, and we turned in a settlement agreement. Um, excuse me, turned in a settlement agreement, normal default with written agreement, and the court rejected it and said, this is a default case, set the case for hearing. The assets and debts are not being divided equally, just all the, and I'm like, you guys are treating this as a default without an agreement, even though there's an attached settlement agreement. So the short story is with Kern County, you have to file a response. And I bring this up because I had a consultation this week. Wife had filed, husband found a video of mine saying, Tim, we saw a video. Thank God we found you. We're just about to file the response, and I'm glad we don't have to. We can save the $435 court fee. And then when we had the consultation, I said, oh, you're Kern County. I said, unfortunately, with Kern, we do have to file the response, and explain to them why, because we cannot have a settlement agreement. You can't participate in the process. They treat a default as a default. They don't differentiate between with or without an agreement. So it's either going to be a default or uncontested where the response is filed. So not a big deal. We just have to file the response with Kern County. And like I said, there's some nuance with certain counties, and that's just the way it works. Okay, I want to talk about a San Diego summary judgment, or summary dissolution as it's known. Summary dissolutions, just to go over that real quick, married less than 5 years, less than, say, $42,000. I forget what it is. It changed once in a while. In community property, no home, no kids, no spouse support. Summary dissolution is a good way to go. And we do several of them a month. Certain counties handle them differently. The majority of them will hold the divorce decree for the full 6 months and then process it, then giving you an opportunity to terminate or dismiss the case before the 6 months has lapsed. With San Diego, and I want to say with Orange County as well, they do it the same way. You file the joint petition along with the proposed judgment, and when they file the case, they issue the divorce decree, or the proposed judgment, if you will, with the date they actually process that document, which is your divorce decree, with the date that your divorce ends. And why I like that is because there's no waiting to get that 6 months later. So let me give you an example. LA County, San Bernardino, Riverside, every other county, you file the joint petition, you get the filing on it, and you also have to mail that in with the envelope. So when the 6 months passes, the court will put like a tickler in their file, or however they're notified, and they will then pull up the case that 6 months later and go, okay, there hasn't been a revocation filed on this, so now we're going to process the judgment. So the whole time, the whole 6 months, you're in limbo. When is it going to come? With Orange County, San Diego, and probably a few others, they actually issue the final divorce date, because all they have to do is say, hey, we're filing on April 23rd. 6 months and a day after that is this date. They process it. You can still revoke it if you like. That's one of the benefits of the summary dissolutions. You can do the revocation, and it'll still revoke it. But I like that they process it. Like we had one today, San Diego. We filed it, got the case number, and then they issued the divorce decree with his final divorce date already stamped on there. He's totally done. All he's going to have to do is absolutely nothing, because when that date passes, he's just officially no longer married. All right. Talked about that already. Okay. New divorce case where spouse was out of country. If you have not filed your divorce, listen to this. Let me back up. If you have not filed your divorce and one of you are out of country, you're going to want to make the spouse living out of country the petitioner, only if you're amicable. And here's why. If you file for divorce with one spouse out of country and they are the respondent, the court will require a notary from the respondent. And that's in every case, not just because they're out of country. They will need to have the name notarized, the respondent's name notarized, because they have not filed a response. This is on a default with agreement. Now, if they file the response, 99% of the time, they don't need a notary. So it's another loophole or another way around it. But if it's a default with agreement and you guys are trying to save that second fee, you want to have the petitioner be the person out of country. And that's the case I took today. I said, hey, run this by your spouse, make sure they're on board, and you guys are amicable, because if we make her the petitioner and then she doesn't sign anything else, or she decides she doesn't want to be cooperative or whatnot, doesn't matter, then we're stuck. Then we're really stuck, because we kind of gave her the reins by being the petitioner a bit, and we can't really finalize it without her. So as long as that's the case, make the party out of country the petitioner, It'll save them from having to go to the consulate to get a notary because that's the only thing the court will accept, and that could be kind of expensive and a pain in the butt to get in to the embassy to do that. All right, e-file issues. As more and more courts come online for e-file, there's still lots of bugs in the system, from them only allowing the initial petition to be filed to only accepting part of the judgment package, but not the entire thing. Hoping this improves. LA County has this down to a science. I love it. In fact, I'm in LA County, so most of our clients are from LA County. We do file in all the other counties, and what we're seeing is slowly the counties are coming on board, and some of them are just getting online, and so all they allow is for us to file the petition. After that, everything else has to be, regular mail filed. I need original copies mailed into my office, signatures, original signatures. And certain counties are super strict, and I don't know if they'll ever come online. Like Sacramento, biggest pain in the butt court to work with. They don't even allow for electronic signatures. So say you're a client of mine in Sacramento, I can't have you e-sign anything, but they'll allow for you to scan to me, as long as it's a scan of your original signature, but they don't allow electronic signatures whatsoever. For me to be able to get your e-signature on paperwork for all of these other courts is amazing, but I have to mail file everything Sacramento still. Solano County, like, we can e-file the initial petition with them and even some of the procedural forms, but they won't let us file the judgment package, the final settlement agreement, and they won't let you file the request to enter default either. And you want to know why? Because I think this is the reason. They don't have an ability to process those and send us copies with the request enter default. That has to be traditionally, an envelope needs to be prepared for both petitioner and respondent. So when it's processed, they can stick it in the envelope. I think they haven't got to the part where they want to do that. With LA County, they are doing that. They're getting them out. There's no back off, or there's nothing blocking LA County from processing the entire case start to finish. And we're just seeing so much ability to get our divorce cases in LA County completed faster. We're in 2024. I hope that these counties come around to the point where we can do start to finish e-file with the courts. I really do. Because right now there's just issues. I had a San Bernardino divorce case. They just came online like last month. And so I filed a San Bernardino case e-file today, and I got a notice of rejection. And I said, oh, it didn't say why it was rejected, just said the whole filing, the e-file was rejected of the initial petition documents. And then about an hour later, you know what it said? It said, because we were filing in the Barstow court, the reason for the rejection says, you need to file your case in the Barstow court of San Bernardino. I said, well, I did. So I was confused on that. Then I got a call from the clerk and said, hey, I mistakenly rejected that. There's nothing wrong with it. I apologize. I said, that's great. I still need conformed copies, filed copies, because once it's rejected in the system, you don't get the copies. And she said, oh, we don't have the ability to do that. I'll have to mail them out to you. I'm like, okay. So it would have been nice. I think she just clicked the wrong button is what happened, what it sounded like. So I guess mistakes do happen. Okay. I got another rejection for you. San Diego divorce case that was rejected, that we submitted, and they said the respondent did not notarize, which they clearly did. I bring this up because the court's being shorthanded with clerks and making mistakes, trying to process judgments fast, resulting in wrongly rejected judgments. So it literally said respondent's signature. This is a default. With agreement, the respondent's signature needs to be notarized. There's neither a signature nor a notary. So I opened up the paperwork. I said, is there possible I did that? I look, nope, there's a respondent's signature, and right behind it's the notary, but they rejected it, and total mistake, total waste of time, just causing delays with processing the paperwork for our clients. Okay, next subject. When people are filing their own divorce and e-filing, they're forced to complete the property declarations, and not only are they being done wrong, but many people believe they have to divide everything equally on paper, and are listing assets and debts as being divided 50-50. We talked about this a little bit, but I want to go a little bit more detail about this whole 50-50 thing, with the whole community property thing. If you read up on it, it says everything needs to be divided equally. So people take that to the extreme. And I was working on a settlement agreement today that they did the same thing. They did the guidance file, did the property declarations, and on the community property, they were listing everything: credit card with $100, $50 to each party, bank account with 50 cents, 25 cents. I mean, exhaustive list. I said, hey, do you guys really want to divide everything down the middle like this? This is crazy. I've never seen anything like this." And they said, "No, but don't we have to divide our assets and debts evenly?" I said, "Well, it's up to you. The court's not going to enforce that. If you guys agree to something that's unequal, that's fine by agreement. If you guys went to court, they would enforce that. If you guys are, fighting and going to a trial and so forth, they'd probably force that. But that doesn't mean, even if you wanted to do it equally, it doesn't mean you have to divide. They had the cars listed, each person getting, half the debt or half the asset. So I said, like, are you guys going to sell everything? Sell your cars? You know, it was crazy. So they said, no, we don't want to do that. I said, okay, so give me the list that you want to keep of this. Give me the list that your spouse wants to keep, and we'll draft that. And it's not going to be equal, but it's fair as far as you're concerned, and that's all that matters. So these property declarations, people, they cause a lot of problems. Not only once it's listed on the petition and attached to the petition, those 160s, you have to make sure you address those. If you have done that, like in this case, even though they showed everything being divided, if it's a default with agreement or uncontested, then you just make sure all of those things are listed on the settlement agreement. You can change your mind on the distribution. But if this was a default without an agreement, that's where you're going to have to actually exactly how you listed the property division on the petition would have to be done on the judgment. And that's why there's such a big pain in the ass. I hope you liked episode 62 of the Daily Perspective. Trying to get these out daily. The most up-to-date daily information on what's going on in the divorce world in California. Have a great day. We'll talk to you.